in this country and the state of California and Marin County, which is what we're talking about right now, we are innocent until proven guilty. What that means in a DUI case is that the prosecutor, that the district attorney in Marin County, has to be able to prove that you're guilty of DUI. And that means they have to, be able to prove to a jury of 12 of your peers that the elements of the DUI offenses are present, that you're guilty beyond a reasonable doubt. Now, what that means is we need to look at the elements here. First one is driving. And then the second one is either you were impaired, or under another charge for DUI that they have, it would be that you were at or over a 0.08 alcohol level when you were driving. So Vehicle Code Section 23152A is impaired driving, and it requires obviously driving. And if the cops arrived at the scene and or they saw you driving, or there's witnesses, driving is usually not the toughest element to be proven. However, when driving is an issue, those are probably the most defensible DUI cases, because we're not battling the issue of impairment or being at or over the legal limit of 0.08. So impairment is basically, were you driving with the care and caution of a sober person? This is where your question about, hey, I'm in an accident, I didn't feel like I was impaired, I just had one drink, but I got arrested for a DUI, and am I going to get convicted of a DUI? And impairment, here we're not talking about the legal limit of 0.08, but we're talking impairment. How does the district attorney prove impairment beyond a reasonable doubt? That's done by the officer's observations of the person that they eventually arrest. And a lot of that can be videoed. It's not always videoed, but that is some of the evidence that can be shown to a jury. And these officers are looking for different signs of impairment. They'll have you multitasking to try and show that you're unable to do two things at once. Talk to them while you're looking for something, or balance and count, or things like that. So it'll be from the time they usually come up to your window if you're in the car, or come up to you at an accident scene. They're going to want to see if they can smell the odor of an alcoholic beverage on your breath. They'll ask you questions. They'll have you do field sobriety tests. Now, the ones that they usually do are the eye test, the horizontal gaze nystagmus test. They'll have you do the standing on one leg and counting. They will have you walk a line. Sometimes they do some other tests, head back, eyes closed, estimate 30 seconds, which is the Romberg balancing test. They don't do much anymore, but the finger count, they used to do that one. You'll still see that once in a while. You rarely see the alphabet test, but all these things are tools that they will use to try and determine whether they think you are impaired. That, along with, again, how your speech sounds, if you're talking with what they call slurred speech. They're looking for how you walk. If when you get out of the car, you hold on to the car. If you're having trouble, you're swaying. All things like that. Now, going back again to your initial question, there's an accident here. That is something that makes these cases tougher to beat, because what the DA knows is that when someone has an accident, that is potentially a sign of impaired driving. As I said before, the question is, were you driving with the care and caution of a sober person? Now, sober people get into accidents all the time, but when you combine alcohol with driving and there's an accident that looks like it's not just a normal looked away for a second type accident, it's from not being able to maintain your lane, or not stopping quick enough, or a number of different things, that can help show impairment. It does not mean that you are impaired, but they don't have to show that you are above an 08 to show impairment. So does an accident help prove to the prosecutor, help prove to the district attorney who has your case in Marin County that you are impaired? and help them prove it to the jury. It is a fact that usually does not help our cases. And therefore, what the district attorney has done in Marin County is anytime there's an accident, their current policy now is that they, under pretty much no circumstances, it's very rare when they will anymore, it's extreme circumstances. And there are certain cases where we can still get charges reduced here, but they're usually not going to dismiss or reduce a case if there's been an accident. It can be a little bumper tap. It could be someone on a motorcycle laying the bike down. There could be a number of different things that happen. But on an accident, no injury, nothing like that, they dig their heels in deeper, and their policy is not to go easier on someone or reduce charges or dismiss charges, even if someone's right there at an 08 or an 09, right at the legal limit. Now, the other count in a DUI case, they'll usually charge you with two things. What I mentioned before, 23 Vehicle Code Section 23152A, which is the impaired driving, and 23152B, which is the per se charge, which basically says that you were driving, and when you were driving, you were at or over the legal limit. That's one, even with an accident, where what we get to do is question the driving and also whether or not you were driving, and at the time that you were driving, whether or not you were at or over the legal limit. Now, there are lots of defenses here, machine error, the machines weren't used properly by the officers. If there's a blood draw, there can be issues with the actual draw, with the testing, and whether it's a breath test or a blood test with the testing equipment. Those chain of custody on a blood test, there's all sorts of things that we can look at, research to try and show that they can't meet the elements of the case, of the offense. And in this case, we'd be talking about being able to prove beyond a reasonable doubt that you were an 08 or higher at the time of driving. So there are defenses here. And going back again to your original question, just because you had a drink and you were in an accident and you got arrested for a DUI, it does not mean that you are necessarily guilty of a DUI. You need to find the best attorney that you can in Marin County and get them to help you defend your case in court and also with the Department of Motor Vehicles.